Hello, konnichiwa. Thank you for joining me today. My name is Dennis Hubbs. I am a U.S. patent attorney and foreign registered attorney based in Japan. I'm doing this recording from our Tokyo offices. Before we jump into the presentation about how to save money on patent prosecution and have a more efficient prosecution experience at the USPTO, let me first briefly introduce my law firm. As I mentioned before, we're based in Roppongi. Myself and another U.S. attorney work here with our Japanese staff. We have an office in Washington, D.C., where my colleagues work. We were the first U.S. law firm to become a Hojin in Japan. So without further ado, let's jump into the topic that we will be discussing today. So we have 7 topics here. The first topic is using big data to review examiner history, to review the history of the art unit, and to try to tailor arguments to the PTO for a specific examiner or a specific art unit. Next, we'll be discussing U.S. practice-focused arguments. So in other words, how to structure your arguments in order to be more efficient with the examiner and not have a lot of superfluous things in our responses. Next, we'll talk about one of my favorite topics, which I believe is underutilized in patent prosecution, and that's how to use your dependent claims effectively. Then we'll move on to examiner interviews, especially with respect to 101 rejections. There's also some IDS practice tips that I would like to relate as well. And then finally, we will get into the AFCP pilot program and moving on to some issues with translations. Okay, so this is a relatively new kind of weapon that we have or technique that we have when prosecuting applications to the PTO. So basically what happened was in 2015, the USPTO opened their database to third-party users. So in other words, a third party could scrape all the USPTO statistics and data by examiner, by applicant, by application number, by art unit, by group. And then we can take this data and we can form a specific strategy tailored to the specific examiner or art unit, etc. So here is an example of some of the statistics that are available to us. This is from the company LexisNexis Patent Advisor. The examiner here is John Smith. I pasted over the examiner's name just to not embarrass anybody. So this is just a fake name, but all the data is real. So you can see this was one of case that I was handling, and real quick you can see that the examiner's allowance rate is 41% and the allowance rate of the art unit is 78%. So this examiner is going to be a little bit more difficult than your average examiner in the art unit. So here the applicant gets a little bit unlucky in that it's just going to be harder to get this case allowed. So this examiner allows only about half the cases that a typical examiner in this art unit would handle. The next slide is another examiner, and this examiner is extremely difficult. So we can already see that the art unit itself is difficult. They have a 35% allowance rate. This particular examiner is extremely difficult with a 12% allowance rate. In the bottom right-hand corner here, you can see the abandoned cases compared to the patented cases and pending cases. There is just a lot of abandonments here. This examiner is someone I know, and it's just very difficult. So when we're tailoring a strategy of dealing with this kind of examiner, you may want to consider appealing the case more quickly than if it was an examiner with a high allowance rate, for example. So we can see this examiner's allowance rate compared to other examiners in the art unit. So he's here at 13%. But if we have this examiner here, Pierre Aliska, this guy's up at 70%. For our strategy, if we have examiner Duncan, we may be more inclined to file an appeal and get the application away from this examiner because we know this guy is going to be very difficult. Whereas if we have examiner Aliska, who has a 70% allowance rate, perhaps we don't want to appeal. Perhaps we just want to file an RCE and stick with this same examiner because we know that this examiner is more likely to allow the case than their counterparts in the art unit. The other big data technique that we can use to help us in patent prosecution, this is actually maybe before we file the application, there is an AI software from Lexis that we will use before we file any US application, and it's called Patent Optimizer. And basically it allows us to review the specification and claims using artificial intelligence, and it will identify issues in the claims, such as antecedent basis issues or a specific claim feature lacking support in the specification. It will also alert us to any duplicative numberings. So if we label something reference character 10 and then we accidentally label something else as reference character 10, it's going to alert us to that. And it's going to allow us to fix the specification and fix any claim issue before filing to the PTO. This can help us because it's going to reduce the number of rejections that the examiner will issue. We're going to address those 112 written description issues and indefiniteness issues before we begin prosecution. Here we want to talk about the best ways to format arguments at the PTO. So this is a very standard way. This is the way that most US patent attorneys learn to formulate an argument in the response to the office action. This is going to reduce prosecution history estoppel, and this is going to be basically what the examiners are used to seeing. So the examiners are going to be comfortable with this technique, and hopefully you're going to get a better examination as a result. So first, we're going to quote the exact claim feature that we want to distinguish. It's best not to paraphrase. You really want to quote the feature so that there's no prosecution history estoppel later. So we have our quoted feature. Next, we're going to quote what the reference discloses. Again, it's best not to paraphrase if you can avoid it. And it's best to match as close as possible the exact language that the reference has. And then finally, the third step is we're going to explain to the examiner the difference between the quoted claim language and the quoted prior art. This will avoid any superfluous or unnecessary discussion of claim features or discussion of the cited art. Very clear to the examiner what is claimed, what the reference says, and then what the difference is. If we use this technique, it can help us avoid some unnecessary office actions. As I mentioned before, this is what examiners are used to seeing. This is what most US attorneys do. It's easy for the examiners to understand, and it can also limit any prosecution history estoppel going forward. So the next topic is about using dependent claims as effectively as possible. This is kind of one of my favorite topics. I get asked a lot by clients about how we can reduce the number of RCEs and how we can get applications allowed quicker. This, I believe, is one technique to do it. So, the first thing we have to ask ourselves is, what's the purpose of a dependent claim? Well, there can be two reasons to have a dependent claim. The first reason is that if our independent claim is found invalid during patent prosecution, we can fall back to our dependent claim and we can assert the dependent claim against the accused infringing product. But for our purposes in this discussion, a dependent claim can also really aid in patent prosecution and reducing the number of RCEs filed in the case. How do we use the dependent claims more effectively? Well, instead of just making one argument about the independent claim, we can make arguments about some interesting features in the dependent claim that the examiner may have not given a lot of weight to. So if we can make a second argument or a third argument or a fourth argument, it's going to reduce the number of office actions potentially that the examiner issues. So, for example, in our independent claim, let's say we have a pretty good argument, but maybe the examiner will agree with it, maybe he won't. If we put in arguments for a narrower dependent claim, number one, it's just going to be more difficult for the examiner to reject the claim because it's narrower. So he's going to have to find prior art that's closer to what we're doing. Number two, if we can make the examiner do another search and find better prior art, that's also going to help us for our independent claims, because there's a good chance the examiner will not hold on to a bad rejection for the independent claims. So if the examiner can find prior art for that dependent claim, it's probably also going to be more applicable to our independent claim as well. So by doing these multiple arguments, we can have a better chance of success and a better chance of receiving allowable subject matter. Now, we can still push on for our broader independent claim, but the subject matter that we have that's allowable, we could just choose to take it, or we could choose to fight on. One caveat I'll mention for this technique is nothing's for free. So everyone in the patent world is is an engineer or scientist, or we work with engineers and scientists, and everything's a trade-off, right? So you want to reduce the number of RCEs, that's great, but when we make these additional arguments, it's going to take us a little bit longer to make these arguments. It's going to be a little bit more work, but we're doing all this work within one response to the office action. So we're not spreading this out amongst multiple responses to the office action. So there is some trade-off, but as long as we can have a dependent claim argument that works, we can keep pushing the application forward, getting more and more allowable subject matter, and hopefully getting a better search by the examiner in the process. Okay, examiner interviews. I'm sure everyone has heard plenty about this topic, but I'll just say examiner interviews can be very helpful. As you may be aware, examiners are under a heavy time constraint. They have to meet certain production requirements, certain number of office actions, every month, every quarter, in order to meet the evaluation criteria. So the examiners may not fully read the application. They're just going to go right to the claims and read the claims. And as a result, their search may be very poor, the rejection may be very poor, and it may just be a waste of time for the applicant responding to an office action that really isn't on point. As such, if we do an interview, we can explain to the examiner what our invention is, what the core feature is. Even if the claims aren't exactly what we want to say, they may not be perfect, but at least the examiner can understand the core idea of what we're trying to get to. This is going to help the examiner do a better search, and in return, we're going to get hopefully a better office action. And this can let us kind of not waste any office actions, jump right into the essential features of the invention as soon as possible. The other thing I'll mention about interviews, and in particular with respect to 101 statutory subject matter rejections. If anybody deals with these kind of rejections, it can be very difficult for everybody. The USPTO rules on this are not very clear. They're talking about an abstract idea. If you ask 10 people what an abstract idea is, you're going to get 10 different answers. The USPTO, I believe, has around 8,000 examiners. It's almost impossible to get a consistent application of the 101 statute because it's just not clear. So you have 8,000 different people doing their own interpretation of subject matter eligibility. It gets to be kind of quite a mess. So if we could have an interview and talk to this individual examiner on what will it take to get this allowed, what claim amendments would help move this thing forward, what the examiner's supervisor wants to see in order for the supervisor to sign off on this, that's all stuff that is very, very much good to put in an interview, whereas sometimes the examiner is not going to be able to, write this out in an office action. For example, if the examiner's supervisor wants to see certain language, it's hard for the examiner to say, hey, listen, I agree with your position, but my supervisor is never going to allow this. So in the interview, the examiner can be a little bit more candid in what'll it take to kind of move this application forward. Here is a pilot program by the USPTO. It's a first action interview program. So we can, if we apply for the pilot, we can conduct an interview before examination even begins in the case. I would say to consider this for important applications. And like we said before, you can get a good search. You can tell the examiner exactly what you're going for. And hopefully the examiner does a good search, finds good art, and you can receive less office actions as a result. IDS practice, this is a kind of a tricky issue. I'm going to give a couple suggestions based on my own experience and what I've seen. The example I'm going to give is if we're prosecuting the application, the client's prosecuting the application in several different countries, perhaps it's a PCT application, and you get, for example, an international search report, and they have X references, Y references, and A references. Some clients would only like to submit X and Y references, and they will not submit in an IDS and A reference because, the A reference is basically what the ISR says is it's kind of related, but it's not a novelty issue or an obviousness issue. This is just kind of other things that we found during the search, and we're not going to apply this reference in the rejection. So for the ISR, okay, that's, that can be reasonable. But let's say a year later, 2 years later, the corresponding case is being prosecuted in, pick your country, let's say Australia. And the Australian examiner uses that A reference in the rejection. So now it's the client policy, the reference has been used in a novelty or obviousness type rejection, so we want to submit it to the US now. The problem is when the US attorney goes to submit, it's often either required or it lets us save money if we can say that the reference is first cited within the last 3 months. If the reference was already cited in the ISR 2 years ago, even if we really hustle and we try to file the IDS for the references cited in Australia, we try to file those quickly within 3 months, we cannot make that certification statement. So it has to be first cited within the last 3 months. Technically, the Australian reference was second cited. So in order to make this first cited certification, we're going to have to go back and look at every single other office action or search report that was performed before this Australian office action. So this can be quite cumbersome and quite expensive for the client. What I would suggest considering is that just, if we're going to file an IDS anyway for an X or Y, just include the A references. The cost will probably not be anything more, at least from the US attorney perspective. So we might as well include that, and then we don't have to worry about any certification statement. So keep in mind, if we're after final rejection, we need that certification statement. If we've already paid the issue fee, we need that first cited within 3 months certification statement. If it's a brand new application, we don't need the certification statement. If the application is after a non-final rejection, the certification statement lets us save 180, or actually it's a $200 USPTO fee. Another recommendation I would have for IDSs is that when you instruct the US firm to file an IDS, put the certification status of the references in the instruction letter. So if you're a US attorney and you see from the client, hey, please file these references at the PTO, you say, okay. If it needs a certification statement, you have to go back to the client if you're the US attorney and see if it's actually been first cited, because the US attorney only sees the US end. They don't see prosecution for the other countries. So it's impossible for them to know if it's first cited, because maybe it's been cited in Australia, China, Europe, Korea, etc. So if you put that statement in the instruction letter, you're saving the US attorney time, so they don't need to draft a letter back to Japan asking if it's first cited or not. The other way it could save money by putting the certification in the instruction letter, especially some higher priced attorneys or firms in the US, instead of writing the letter back, they may just say it's not make the certification statement. So if it's a non-final rejection, they just may pay the $200 because they're not sure if it's been first cited or not. And maybe writing a letter back to the client and going through it would cost more than $200. So they say, hey, listen, we're just going to save the client money in the long run. We're not going to make the certification. We're going to pay the USPTO fee, and it's going to cost the client $200 when perhaps we could have saved the client that money. QP IDS, this is relatively new. It's been around for a few years. After we get the notice of allowance and we pay the issue fee, we're allowed to do a QP IDS, Quick Path Information Disclosure Statement. Before, if we wanted to file an IDS after paying the issue fee, we would have needed to file an RCE and a petition to withdraw from issue. It's really expensive. It was really a hassle. Now we can do the QP IDS where we just file this. If the examiner wants to reopen prosecution based on the cited references, they're going to accept the RCE and prosecution will be reopened. But if the examiner doesn't, then the RCE doesn't get accepted and the case just goes on to allowance. But to my point on the previous slide, we also need to make the 3-month certification to use the QP IDS. After final continuation pilot, so this is something that we can do if the application is perhaps close to allowance. We have a final rejection. We're allowed to amend the independent claims to add a feature, and we request entry under this AFCP 2.0 pilot program, and the examiner will get an extra few hours to enter the amendment and review the claims. It's up to the examiner's discretion on whether or not to enter the amendment, but if the application is close to allowance, the examiner can enter the amendment, and that can avoid us having to file an RCE to get the amendment entered and ultimately the case allowed. So if we're after final and we think the case is kind of close to allowance, this could be a really good way to avoid filing an RCE. Getting toward the end here, high quality translations, you guys know better than I do, going from Japanese to English or English to Japanese can be very difficult. This is why, an interview is very helpful in certain circumstances. I see it a lot where the examiners don't really understand the invention. They just have a limited amount of time. They're perhaps reading only the claims, skimming over the specification. So as clear as we can make the invention to the examiner, it's going to make our life easier during prosecution. So if you can have someone who speaks English well look over the application, that can be helpful. Again, you could use the patent optimizer that we discussed before, where it's going through the claims and the specification, and that can help you identify things that are not clear. This can help us have a more efficient prosecution as we're going forward. Finally, some other tips to reduce cost. These are kind of minor things, but it could be helpful. When we file a new application, file it with the declaration. We can avoid a USPTO fee of $160 for a late filing of the declaration, and you can avoid the attorney fee of having to file the declaration, a few months later. Another thing we can do is a pre-appeal brief request for review. This can be a good strategy when the examiner is being kind of stubborn. So again, if we were looking at our patent advisor statistics for the particular examiner and the guy has a really low allowance rate, we could consider doing a pre-appeal brief. What that'll do is it'll go to a small group of examiners, so 3 examiners, the main examiner handling the case, a supervisor, and then another senior examiner, and they're going to look at the arguments and determine if our examiner is being unreasonable or not. If they agree with us, they can allow the case or tell the examiner to do a new search or new rejection. If this panel does not agree, then it just continues, the application continues to the appeal. So that kind of concludes the presentation. If you guys have any questions, please feel free to reach out and give us a call or send us an email, and we're happy to discuss anything further. And once again, thank you very much for joining us.